All right, welcome everyone. Hope everyone had a good summer. We're back at it. This is the
I don't think we're able to hear.
Not sure if it's me or if it's on your end, but I can't hear the chair.
I can't hear either.
We should.
no, you can start over.
All right. Oh, I think I see the problem. We had it double.
Now we're back. We can hear Nate.
Yeah, we had it double muted. Madam Chair, if you could call the meeting to order again. Thank
All
you.
right, great. Hi everyone. I'm Kelly Mitchell, Chair of the Sentencing Guidelines Commission. I'm calling the meeting to order. It's September 8th, 2022, and we are holding a hybrid meeting authorized by law. Welcome back. Let's have Nate go ahead and read the roll.
Roll call, Estrada.
Present.
Estrada present. Hansi.
Present.
Hansi present. Ibrahim. Ibrahim.
Present.
Ibrahim present. Knudsen.
Present.
Knudsen present. Ladd. Ladd.
Present?
Ladd present. Larkin.
Present.
Larkin present. Middlebrook.
Present.
Middlebrook present. Moore. Moore absent. Morath.
Present.
Morath present. Schnell.
Present.
Schnell present. Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 10 members present, 1 member absent. Oh, I'm sorry. Let me go back. Roll call. Moore.
Present.
Moore present. Madam Chair, there are 11 members present, no members absent.
Right under the wire. Welcome. All right, so the first item on the agenda is approval of the agenda. I would entertain a motion to approve the agenda.
So moved.
Commissioner Schnell moves and Commissioner Middlebrook seconds. Any discussion? Commissioner Larkin.
Thank you, Madam Chair. I have provided written notice that I question whether the budget request change item should be on the agenda as an action item as opposed to for discussion. The proposal is, oops.
Can I just make a comment for members of the public who may be watching? Although this pertains to item number 2, the approval of the agenda, it also pertains to item number 6. So you can find it on the website numbered as item 6B, the notice to which Judge Larkin is referring.
And the reason I did that is because the suggestion is, for the first time that I've been on the commission, which has been several years now, I think that perhaps we would do a comprehensive review and rewrite of the guidelines. And although the substantive components of that are not part, perhaps, of what's on the agenda for today, there's a request for funding to do that. And I just feel like that is such a big proposal in which I and my stakeholders are interested that the commission should have more time to digest it and discuss it before deciding whether to go forward in the form of a request for funding from the legislature. However, I don't want to take us too far off track at this point. So if we could maybe just agree that when we get to that point in the agenda, one of the things we could discuss is whether we should be voting on this or holding over to the next meeting. And if Nate could confirm, as I understand the items that were posted, we will have another meeting before the deadline for making the request. So I don't think this would prevent you from going forward. It would just give us another meeting to digest everything.
That's correct, Madam Chair. And in fact, one of the items I don't have a dollar yet because I have to talk with the IT staff. So I was planning on bringing it back in October anyway. So October 17th is a hard deadline. I do have to have all change requests to the Minnesota management budget at that time.
And we're scheduled to meet on the 6th. So would that be enough time?
Yes.
Well, then maybe I will make the motion as opposed to putting it off until later in the calendar, that this be changed from an action item to a discussion item.
Yeah, we have an active motion on the floor, so I think either we would need the folks who made the original motion to accept a friendly amendment, or we would have to vote on the motion that we've already been.
I'll just withdraw the motion, and Judge Lecker, if you want to make a different one, that would be fine.
Okay, so the motion's withdrawn. Do you want to make a motion to approve the agenda with that change?
I make the motion to approve the agenda with that change. Thank you.
All right, do we have a second for that? We have a motion to approve the agenda, changing item 6 to discussion rather than action.
I'll second it.
And Commissioner Knudsen seconds that. Any further discussion? All right, hearing none, let's take the vote on that.
To the Larkin motion to approve the agenda amended to change item 6 to a discussion item. Estrada?
Yes.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Ibrahim?
Yes.
Ibrahim, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
Okay, with that, the agenda is approved. And we will move on. Next item on our agenda is, still have another one we have to vote on. Approval of draft meeting minutes from July 21st and July 28th. So the roundtable minutes and also the meeting that we had directly after the roundtable in July. So I would entertain a motion to approve those minutes.
Madam Chair, I move to approve both sets of minutes.
Okay, Commissioner Ladd makes the motion. Commissioner Larkin moves to approve both sets of minutes. Do we have a second?
Second.
Commissioner Middlebrook, I saw first. Any discussion? All right, with that, please go ahead and take the vote.
To the Larkin motion to approve the minutes of the special meeting in July and the regular meeting in July. Estrada?
Yeah.
Estrada, yes. Hansi?
Yes.
Hansi, yes. Ibrahim?
Yes.
Ibrahim, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath? Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes,
Chair Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
great. And with that, the minutes are approved unanimously. Okay, so we do have a new member today. We are going to do our normal welcome rounds, but we're going to actually do that second. First, we have some guests who have some time sensitivities today with their own schedules. So the next item on our agenda is to learn a bit more about the efforts being undertaken in Washington and Pennsylvania to do comprehensive reviews of their guidelines. I know that we have Carrie Ann Jetzer online from Washington. I'm not sure if Pennsylvania is on yet right now, so maybe we could start with Carrie Ann.
And I'm just checking our attendee list. Oh, Mark Bergstrom is an attendee, so I'm going to make him a panelist.
Oh, there we go. Okay.
All right. So, and Carrie Ann, just because I had him first on the agenda, I'm going to make Mark first presenter. Sorry about that, Mark. All right, would you like
Actually,
me-
I think it's exactly where he should have been, was relegated so that we couldn't see him. But, that's just my personal take.
All right.
All right, well, anyway, I wanted to thank you to both Mark Bergstrom and Carrie Ann for attending our commission meeting on somewhat short notice. We heard really great presentations from these folks at the National Association of Sentencing Commissions, and I really thought the commission could also benefit from hearing some of that. So I'm going to turn it over now. Welcome to the Minnesota Sentencing Guidelines Commission.
Thank you and good afternoon. How are you all? Nate, I don't know if you have the slides that I provided that you can share those, or if I should be trying to share those?
It's up to you, Mark,
Yeah, if
however
you
you
could-
prefer.
If you could share them, that would be better because
Okay.
technology is, it is what it is. So.
All right.
And as we wait for that, I do want to mention that this must be the week for Sentencing Commission meetings because yesterday I met with the Kansas Sentencing Commission. Yesterday and today our commission was meeting, and now this meeting. So it's the trifecta, and it's a pleasure to be with you. When the slides are up, as the chair said, Pennsylvania has been engaged in a review of our sentencing guidelines. We always follow the lead of Minnesota. So, we always think back to when our guidelines started in 1982. We were looking at Minnesota then and thinking about how we would develop guidelines and what we would look at. And that was part of the development of our guidelines. And then as I'll mention with the presentation, in the early 90s, we were doing what we considered the first comprehensive review of our guidelines, about 10 years into it. And one of the things we did at that point was sort of benchmarking. And interestingly, the benchmarking was with Minnesota and Washington State in terms of looking at guidelines and thinking about things that we would do differently. And so we'll take it from there. So, yeah, Nate, I don't know how we're doing on the slides.
Yeah.
There we go.
I was having trouble making myself the presenter. So
Oh, no.
sorry about that.
Well, still, you're doing this way better than I would. So thank you for that. So maybe I'll just give you a heads up when to switch slides and feel free to switch them at this point. Or turn to the next slide, rather. There we go. So just as a little bit of background, because, Minnesota's been at this for so long, some things that are similar and maybe different between Pennsylvania and Minnesota regarding guidelines. One is that Pennsylvania has an indeterminate sentencing system. So we have parole, and for any sentence of confinement, whether it's in a county jail or state prison, our courts are required to impose both a minimum term and a maximum term. And there's all kinds of rules about that. But the bottom line is that our sentencing guidelines for confinement link to the recommendation regarding the minimum term of confinement. And the reason for that back in the 80s when we first developed guidelines was that at that time, individuals were generally paroled at their minimum. So it seemed like a good starting point for our guidelines. And then the person would be under community supervision under parole until the expiration of the maximum term. And so we have just continued that as a legacy of always linking our confinement recommendations to the minimum term. And so that has it's a legacy of our guidelines. Our sentencing guidelines are advisory guidelines. And so we do build into our guidelines many factors for courts to determine at sentencing based on a preponderance of the evidence rather than on proof at trial. And so that, I think, gives us some flexibility in terms of factors that we make sure are part of the guidelines. And I can say as an aside, one of the areas where we exploited that was to encourage our General Assembly to consider the use of what we call enhancements in lieu of mandatory minimum sentences. So the courts would be required to consider on the guidelines certain factors, but the courts would have the discretion to depart from the guidelines, but at least those factors were in consideration. And that, of course, would differ in a large degree from how mandatory minimums would operate. We do have appellate review in Pennsylvania. Courts are required to consider the guidelines, and our guidelines apply to all misdemeanor and felony offenses. But our appellate review is weak. The standard is manifest abuse of discretion. So aside from legal issues on the discretionary aspect, it's pretty weak appellate review, but there is some. And we know from in talking to judges, it's not so much that the appellate courts would remand, but it's all of the work involved in dealing with appeals. So there is some benefit in having any appellate review linked to discretionary aspects that courts tend to give some deference to the guidelines, even if there's not strong review. Our guidelines are intended to be a common starting point for about the typical sentence for the typical offender, typical case. And so we think about that when we think about coming up with guideline recommendations, and especially when we're using data to apply to determining sentence recommendations. We often then think in terms of the median sentence, both in terms of the disposition of the case and the duration of the case that we're recommending. As far as timeline, as I said, our first guidelines went into effect in 1982. We have since had 19 additions or amendments to our guidelines, and a lot of those happened in recent years. And part of it was exactly what I mentioned, that there was a move away from mandatories, but the result of that was our General Assembly enacting, several times in each 2-year session, additional enhancements for the commission to consider and build into the guidelines. And because we wanted to be very responsive to the General Assembly and to promote these as alternatives to mandatories, we wanted to act quickly on that. And we have a whole cycle we have to go through for adopting guidelines. We have a submission to the General Assembly for review. It's sort of a legislative veto. So we were getting in a process of every year doing amendments to our guidelines. That wasn't great for practitioners. It wasn't great for staff. And so one of the things we wanted to think about was how could we come up with a more systemic and comprehensive approach to some of these changes that would anticipate and take into account legislative action so that we weren't revising the guidelines all the time. So I mentioned we did a comprehensive review in the 90s, and that was really about thinking in terms of like two directions. One was, how do we better incorporate things like clinical treatment as an alternative to incarceration? So that was sort of on the lower part and very much about diversion. But we also noticed that when we were benchmarking with Minnesota and Washington State and others, that we were pretty modest in our recommendations regarding serious and violent offenders. And so we sort of moved in the other direction there. But that was the last comprehensive review. So a number of years ago, we started this new comprehensive review. And we anticipate that we will have new guidelines going into effect January 1st of 2024 based on the schedule we have in place for these revisions. So next slide, please. So here's the process we've gone through as part of this review. And again, we started in 2014, and just to get us to the current place where we are, in 2014, we established what was called a strategic planning work group. And we met with this group for 2 years. It was about 40 people throughout the Commonwealth, both in terms of, we had, all of God's children. So we had, judges and prosecutors and defense attorneys, probation officers, treatment professionals, law enforcement, and then academics. And we had just a lot of people at the table, and we wanted to purposely have people that were familiar with the guidelines but weren't like wedded to the guidelines or to the commission. So the structure we put in place really was sort of light-handed in terms of commission engagement. The chair of the commission at the time was chair of this working group, and I was sort of lead staff. But both of us sort of kept each other in check in terms of being there to inform and provide information to the group and have other staff provide data analysis and so forth, but really have this group really decide what they wanted to do, what they thought was appropriate. And what we asked them to do, and this was sort of the mission statement, was to think about if we didn't have guidelines or if you were doing it all over again, what would you do? And the one structure we used for that analysis was that SWOT analysis. What are the strengths of the current guidelines? What are the weaknesses? What are the opportunities and what are the threats? And so that sort of guided the initial inquiry, and then we went in whatever directions they wanted to go to talk about things they liked and didn't like or how they rebuild guidelines. When that group completed its work and came out with a pretty solid report with a lot of things sort of coloring outside the lines, some things that look sort of federal in practice and some things just that were foreign to Pennsylvania. We took that report and we presented it to the commission. And the commission was surprised. We tried to keep them in the loop on some of this, but we didn't want them actively engaged in this. We wanted some deniability here. If things came out in the report that didn't seem appropriate or necessary, we wanted them to have the ability to walk away from it. But on the other hand, we wanted this to be a knowledgeable and informed product that was provided to them, sort of an external review. And so we took that report, provided it to the commission, and the commission took 3 steps. One, it gave the report to staff that were not involved in the process to have them do a vetting and a review of it and to provide recommendations. Secondly, we sent the report to the Rabin Institute at the University of Minnesota Law School and asked them to do a review of it because they would have a more national perspective on things. And then the commission established 3 subcommittees. And the subcommittees really worked at looking at different aspects of the report. So one aspect was offense-related aspects. Another was offender-related aspects. And I can't tell you, I recall what the third one was, but there was a third subcommittee, I think, looking at ancillary issues. We also engaged with other research partners. So the commission is affiliated with Penn State. And so we have a research partnership with Penn State. And that was part of our analysis to start with. But we had a lot of work done by Carnegie Mellon University, especially on prior record score and some of the analytics. And then Drexel Law out of Philadelphia was very involved in thinking through some of the policy issues related to things like lapsing of prior record and so forth. So that was sort of the structure for that initial review. Since then, other factors that went into our comprehensive review include the AOI model penal code for sentencing, and you know this is a gift to sentencing commissions because first you have someone like Kevin Wright who's thoroughly informed about this as the reporter, but also you have a new section on sentencing commissions and on sentencing guidelines. So even if these are things that our commission would reject, it was a lot of great work and a lot of good information, and we wanted to look at that and sort of benchmark against that when we were making decisions on the review. We had justice reinvestment, as many other states have had. We had an earlier justice reinvestment, JRI 1, which focused on the back end of our system, corrections and parole. So we had a second JRI 2, that was from 2016 to 2019, and they focused on the front end of the system and on sentencing. And the takeaway from that was the commission should have much more tailored and focused sentence recommendations. Recommendations should be more singular in terms of a single disposition, not a range of dispositions, and that we should have more, we should just be more focused and data-driven in our sentence recommendations. We then finally had an academic review panel. So we assembled 12 academics, some from within the Commonwealth and some from outside that were subject matter experts. And we wanted to make sure we covered a lot of disciplines. So we had people at the table that weren't familiar with sentencing guidelines or sentencing. We had anthropologists at the table, but we also had people that had worked in the juvenile justice area, people that worked with substance abuse. We included our 2 historically Black colleges and universities in the review because we wanted to look at race and ethnicity. So it was a really great panel because, again, you had some people that knew this stuff inside and out and some people that were new to it. So they were like the public. And it was a great panel to have them help us think through the process. All of this resulted in us publishing what we called a working draft of proposals. So in January of this year, we published this draft that basically put out these concepts and said, this is the introduction of something like that's new and different about guidelines and some big changes that we're talking about. And we just want to get your take on it. So we published this and then we held 6 public hearings. And one of the public hearings, excuse me, was exclusively for individuals in the custody of the State Department of Corrections. So we had, I think, 4 institutions involved by Zoom, and we had public hearings with them. plus many other public hearings that were really very helpful and insightful. Next slide, please. So when we were thinking about building these guidelines, one of the concerns we had in our system was that it would be another stovepipe. We do all kinds of things with sentencing guidelines, but it didn't in any way address parole or revocations of probation or other things like that that are linked to our system. And what had happened over time in Pennsylvania was our commission was given a lot of other mandates. So we had a mandate to change our sentencing guidelines to take into account retributive and risk factors and have adjustments to take those into account. We had these enhancements as alternative to the mandatories. And just to give you a sense, I think we have 20 enhancements that are part of our guidelines. So a deadly weapon enhancement or an enhancement regarding sexual abuse of children, which is child pornography. We have just a lot, domestic violence, a lot of enhancements. So those are part of the mix. We're required to have guidelines for fines and community service, for probation, and for the use of restrictive conditions of probation. And we also have a new mechanism where the commission has oversight of certifying compliance with the use of these special restrictive conditions of probation in terms of compliance with the guidelines and the statute, but also that's linked to funding of counties for those programs. So all of these were considerations when thinking about our sentencing guidelines. But we also were required and have put in place a sentence risk assessment instrument, a second generation instrument, to try to identify what type of additional information might be helpful to the court prior to sentencing. We have resentencing guidelines for recommendations for violations of probation and revocations of probation. We have parole guidelines for our state parole board and recommitment ranges for revocation of parole. So when we're thinking about all of these, we're thinking sort of an enterprise effort, a systemic way of thinking about better coordinating our system as we have responsibility for all these various guidelines. Next slide, please. I think we're getting towards the end. So taking all of this together and thinking about this comprehensive review, here were some guiding principles about what we were trying to achieve. Number one, we wanted to simplify and stabilize the guidelines. We wanted them to be easier to use, easier to understand, and we didn't want to have to change them every year. Next, we wanted increased certainty. We wanted to make sure if parties were negotiating a sentence around the standard range of the guidelines, there was consideration of important and common factors, and they were treated in the same way across the Commonwealth. Next, we wanted a reduced impact on criminal history, especially because of racial bias. And I give great credit to Robina and to Richard Fraze and to all of the people there and Kelly for everyone who's done all the work on prior record score criminal history. Really important work, really raised, I think, our consciousness about prior record score and how we deal with it, and pointed to the racial bias that's in the system that we contribute to in terms of how we use criminal records. So very important area, and our academic review panel really focused on that. We wanted to have more targeted recommendations. And so we moved towards individual levels of sentencing based on the disposition. So no supervision at all, probation, county jail, state prison, and then different types of state prison for things like murder or other things like that. So very specific dispositions and then much narrower durations. And with the prior record score, a general rule for general prior record score categories of no more than doubling the base recommendation. We wanted to incorporate evidence-based practices and reduce reliance on incarceration. We wanted to automate as much as possible. We have a pretty rich and useful web-based application for our guidelines and for the reporting of all sentences to us. And at the high water mark, we were getting 150,000 sentences a year, but there was a lot more that we could automate. And so the focus of this is rebuilding our application as we rebuild the guidelines so that we have as much automated as possible. And then we wanted to coordinate and integrate, like I said, with all those responsibilities we have. We especially wanted to think about the connection between sentencing and parole decisions, about decisions between county confinement and state confinement, or county supervision and state supervision, because our counties play an outsized role in delivering correctional resources, both jail and community supervision. And then we wanted to coordinate between initial sentences or parole decisions and revocations of either of those. So the next slide, and here's my closer. So this is our current matrix. It's very colorful, but very broad ranges. And our 5 levels really are very broad categories that provide courts a lot of discretion. And courts love discretion, and they need it to individualize sentencing. But, you know, they should have some direction too. And so we had 5 sentencing level, 14 offense gravity score categories, so offense categories. We have a 15th, which dealt with murder 1 and murder 2. And then we have 8 prior record score categories. And under our current prior record score scheme, we could be increasing the base sentence recommendation by up to 9 times in certain categories of the prior record score. So next slide, and this is my final slide, I think. So this is where we are right now, and it will change, but we have moved from effectively 14 basic categories for our offenses to 30 basic categories, but they're much more proportional in increases, and our levels are much more linked to specific sentencing options available to the court, and our ranges are much narrower. And as a general rule of thumb, the prior record score, except for repeat violent offenders, which we treat as a special category, generally do not do more than double the prior record score recommendation. So lots more I could talk about, and I appreciate all of your time and happy to answer some questions. Here's my contact information, and I'll throw it back to the chair.
Thanks, Mark. I really appreciate it. I really appreciate the presentation that you gave. It's really fascinating to see how the different systems work. I want to open it up for a couple of questions, but one thing I want to make sure everyone on our commission understands is Pennsylvania's guidelines actually cover all levels of offenses, misdemeanors and felonies, whereas ours only cover felonies. So that's why you see a lot of those local sentencing options as well at the bottom of the grid. Commissioner Larkin, I think you had a question.
Yes, and thank you for the presentation.
Sure.
Did I hear you say that the enhancement factors on which courts rely to increase the sentence need not be put to trial, they just need to be proved by preponderance of the evidence?
That's correct. Our enhancements are sentencing factors, and because we have advisory guidelines, they can be considered. We have to stay within the statutory max, so we cannot exceed the statutory max. That's an Apprendi issue, but we have guidelines that take into account of these other sentencing factors, and they're used to adjust the minimum sentence recommendation.
How is it that you don't need to have a jury trial on your aggravating factors, which we have to do here in Minnesota?
Because number one, because they're advisory guidelines, they're not presumptive guidelines. And number two, because the sentence recommendation remains below the statutory maximum. So if we were exceeding the statutory max, we would have to prove additional factors, absolutely. And if we had presumptive guidelines or mandatory minimum sentences, any of those factors you'd have to give notice, and they would have to be proven at trial. But that's the difference with advisory guidelines and making sure we remain below the statutory limit.
One follow-up?
Sure, go ahead.
So if they're advisory guidelines and the judges don't have to follow them?
They have to consider them, and there's, as I said, weak appellate review, but but what we find is there's relatively high conformity, and I think there's at least 2 contributing factors to that. Number one, what we've heard from judges is the effort required to deal with appellate issues, even if the courts are going to uphold you, provide some tempering on courts adhering to the guidelines because it's a safe harbor. And the second thing is that under our system in Pennsylvania, we have elected judges and we publish sentencing data. So our sentencing information is available to the public. We go through a screening process, but all of our information is available, and it's judge-specific information as well. So that is there's a transparency in this process that we have found actually promotes courts in articulating reasons for going outside the guidelines, because it's subject to public review, and to some degree that may enhance the consideration of the standard range as a safe place.
Thank you. Other
Thank you.
questions, Commissioner Stel?
I really appreciate that presentation. It was very helpful.
Thank you.
I'm intrigued by this whole notion of this enterprise approach that you took. And we've had, I think, conversations have been around this, right? Where we focus on, where certain offenses fall on the grid and so forth. But I would say we probably don't take that enterprise focus. Would it have been conceivable to you that you would be in the same place if you didn't take that broader view of looking at the totality, probation and effective responses, those sorts of things as part of this review?
Yeah, I think we're always going to get there. I think, just like any jurisdiction, you're always looking at what leads to people coming into your system and where do they go from here. And we're all really concerned about outcomes, what works and what's the most effective intervention in a case. So I think that's why we're all interested in risk and needs and about, clinical prescriptions and things like that. So I think, we were moving in that direction, but there were two things that I think helped us get there faster or made this comprehensive approach necessary. One is that statutorily we were given responsibility for some of those subsets that were that I talked about. So we have to do probation guidelines as part of our sentencing guidelines. We have to do guidelines for fines and community service as part of our general sentencing guidelines. And we have to do guidelines for the use of these restrictive conditions, both as a trade-off to incarceration, but also so that there's limits and appropriate use of those kind of programs. So we have, not only statutory authority, but we have mandates to do that. And then because we're an indeterminate sentencing system, what we found over time, and this was before we had the mandate, but we found over time that things would be happening at sentencing, or we'd be recommending things at sentencing that were 180 degrees from what the parole board was considering at parole. And it didn't make a lot of sense, and it didn't make sense to offenders either, and it probably didn't lead to good outcomes. And so we received the authority to do parole guidelines and recommitment ranges. And I'm not sure that we're doing like these earth-shaking things, but what it led to was us collaborating closely with our parole board. And in fact, we worked with Robina as part of that, but we've spent 10 years getting to know each other's business and really just thinking collectively about how we do what we do to improve outcomes and to better manage resources. And so I think, these things helped us, but I think we all sort of were at the point where we better all work together because there's too many of these individualized decisions that sometimes are counterproductive. So I think all of that, has come to play.
Thank you.
Thank you.
All right, well, Mark, I recognize that you have your own commission meeting to get to. I really appreciate your dropping in on our commission meeting today and giving us that presentation. Thank you so much.
Well, I appreciate the offer, and I believe I owe you maple syrup, so, keep watching. So, thank you. Take care. Best wishes. Thank you all.
Not coming to the whiteout game, though. I'm sorry.
Give it some thought. We'll be here. Thank you. Bye-bye.
Have a good day.
You too.
All right, so next on the agenda, Carrie Ann Jetzer from Washington. Thank you so much as well for dropping in on our commission meeting today, and we're excited to hear what your commission has been up to.
Yeah, interestingly, my commission meets tomorrow. So this is the week of commission meetings, apparently. So I have the ability to share, correct? Okay, good. Where did you go?
It might be on a different screen. This happened to me yesterday.
Okay, it is. Yes.
Yeah.
Okay, can you see the presentation?
We see the presenter view, not the presentation, so.
Oh. Okay.
You might have to just share a different screen. That's
Or you can just do display settings and swap presenter screen.
Yeah, except
Or you can let me do it.
you know, I think it's probably better if you did it. Let me get out of this. Yeah, I've got two screens and a laptop, so it for some reason went to the laptop.
yeah. That happened to me yesterday in a presentation I was giving, and I was so lost. So I totally sympathize with where you're at right now.
Okay, so while he brings that up, I can just give a little background into the Washington guidelines, sentencing guidelines. Like Mark had mentioned that Pennsylvania looks to Minnesota and Washington. Washington likewise looks to Minnesota and Pennsylvania, probably because they're like the top three, who started guideline systems. So we've been around the longest. In 1981, so the Sentencing Guidelines Commission was created. We are, next slide, please. Thank you. We actually advise the governor and the legislature on issues related to adult and juvenile sentencing. In 2011, we were functioning all the way up until 2011, when we were eliminated as an independent agency, and the policy part, the commission itself, was moved under the Office of Financial Management in the Forecasting and Research Division. And as of a year ago, this past July, I became full-time for the SGC. Otherwise, I was a half-time person. Our review is still ongoing. So what I'm going to be providing is kind of where we're at so far. Next slide, please. So unlike Pennsylvania, the motivation for our review is external, came through the legislature. In 2015, it came out that there was a coding error with the Department of Corrections, which caused early release of about 3,000 people. So there were investigations into why and how and who, and it was found out that it was really rose above that the Washington Sentencing Code is very complicated. And so the as these hearings were happening, the SGC started discussing the need for a review. And so we kind of started talking about it. And then by 2018, the legislature actually directed the SGC to conduct a comprehensive review of the SRA and make its recommendations. And this is about 40 years after the implementation of the SRA. So, no, you're good. There, thank you. So the SGC had completed a couple of reviews before. Oh, excuse me. Back up. So this is a copy of the review that the SGC completed. I'm sorry, I'm backing up. I'm confusing. Next slide, please. Thank you. So this is a copy of the review that the SGC did. There are about 20 recommendations, and this is kind of an example of some of the recommendations. We had maybe about a year to complete this, and we were given funding, being that I was full-time at the time of this review, but we were given funding for the Council of State Government to provide some analysis because we didn't have that. So it even though it's supposed to be comprehensive, it's very upper level look and somewhat limited just because of the time. we had completed reviews in 1991 and 2001, but those studies were basically to determine if the current sentencing practices were consistent with the purposes of the SRA. This one's a little different. It's more about where are the gaps and what can we do better. As everybody there knows, when the SRA was created in the 80s, the idea was that nothing worked, and we know that that's no longer true. Next slide, please. Thank you. So once the SGC completed its study, the legislature directed the William D. Ruckelshaus Center to facilitate the Criminal Sentencing Task Force to further those recommendations. And they were guided under three purposes: to reduce sentencing implementation complexities and errors, to improve the effectiveness of the sentencing system, and to promote and improve public safety. Initially, this was funded from July 2019 to December 2020. And we had have a multitude of members, much of which overlap with the Sentencing Guidelines Commission. We have 3 co-chairs. The first meeting was in September 2019, and recommendations are made by consensus, not by voting, but by consensus, which I'll get into a little bit. Next slide, please. This is taken from their a presentation, the Criminal Sentencing Task Force presentation on what the consensus process looks like. And it's actually even a little more complicated than that, because we had this thumbs up, I like it, thumb sideways, I can live with it, thumbs down, I can't live with it process. But when some people were thumb sideways voting on some of the recommendations, and then those recommendations came out, went to the legislature, and then they were opposed to them because of some other small change, they kind of got grilled. So we've broadened out what that recommendation is, whether there was mostly thumb sideways, mostly thumbs up, just so the legislature knows, because if all members are sideways, that's consensus, but that means something different than if most members were thumbs up. Next slide, please. So the Criminal Sentencing Task Force, again, in December 2019, issued a preliminary report. There's only 4 meetings that happened, so there are only 2 recommendations related to community supervision that were in that report. The December 2020 was essentially the final report, and reported on the 4 work groups that did some work and brought it back to the full task force. That report had 47 recommendations, one of which was to extend the task force through 2022, because there's just so much work that needed to be done. And at that point, we hadn't even talked about the grid. So we also found that we needed more data, we needed information, we needed research. So we suggested that they contract with the Institute for Public Policy to examine the use of a current grid and a potential a different grid that had been mentioned. So today, the legislature extended the task force until June 30th of 2023. We have 2 work groups that are left: the Sentencing Grid Work Group, Sentencing Alternatives. The Sentencing Alternatives have actually wrapped up, so they are no longer meeting. The Washington State Statistical Analysis Center is also providing a little bit of research. They were able to slide it in under one of their grants, providing a limited analysis of some criminal history score rules. The final report, which now might be Part A, is going to be presented at the end of 2022. I say Part A because, again, we are just working on the grid right now, and there's many other aspects, which I'll kind of show, that may still need discussion. It's just so much, and it's just never been looked at that before, that it's taking us more. And as you know, Pennsylvania's been working on there since 2014. So having started this in late 2019, really haven't allotted that much time to it. Other sources that we've used in our review, as I said, are Pennsylvania and Minnesota. The Rabina Institute, we've taken, I've got that source book printed out that I use quite frequently. We also use the Model Penal Code, as Pennsylvania did, and have incorporated or recommended pieces of that. Yeah, so next slide, please. These are just some of the recommendations in the 2020 report, eliminating sentence enhancements, changes to community supervision, suggested removing barriers, dealing with legal financial obligations. Next slide, please. And legislation so far, there was a mental health sentencing alternative that was recommended and passed in 2021. There are changes to the legal financial obligations that passed last year. And there was a bill related to sentencing enhancements, which eliminated the protected zone, because we're finding out like entire cities are protected zones, the way that they're set up. Multiple firearm and dangerous weapon enhancements are currently mandatorily consecutive. Looking to change that, and there's no earned time release, so that's all basically it's a mandatory minimum. I mean, really, when you look at it, if it's a 5-year enhancement, it's a mandatory minimum because it has to be served straight. That did not pass, and part of the reason for that, next slide please, is because of the State v. Blake ruling that came out in February. The Supreme Court declared that the strict liability drug possession statute was unconstitutional. So simple possession was no longer a felony. The legislature had to change its focus and its priorities, had to deal with how to resentencing everyone who had been sentenced to that since like the 70s. Deal with legal financial obligations that people were owed back because of the change in this ruling. And so much attention was given to that few criminal justice bills were actually approved that year. Next slide, please. So in the 2022 report, most of the work, as I mentioned, is on the sentencing grid, is on sentencing alternatives, which is tied to the grid, and criminal history scoring rules. We did start consensus deliberations last week. We had 2 meetings regarding the grid, and we still had not, we still have 3 people that are can't live with it, so we're still trying to work through that part of their concerns. As of right now, there's about 40 to 50 potential recommendations, but some of those recommendations have multiple options, an A, B, and or C. Next slide, please. This is some of the components of the grid that we have looked at. We're still dealing with like 3 strikes, dealing with some of the multipliers. Some of that will be happening now. We're having to re-triage, I guess, things that are related to the grid. We want to be able to put forth something at the end of the year, and anything that we don't get done, because the task force is technically around until June of next year, we may consider continue discussions next year, hence the part B of the final report. Next slide, please. This is an example of the draft grid that we're talking about. The colors are just illustrative right now, and actually there's a few more colors. But the greens are basically all our class A's. The orange would be class, excuse me, let me back up. The green is our class C's, B's, and A's. Orange are class B's and A's. And then the yellow and the white would be the class A's, with the white being our serious violent offenses. We increased our grid from 16 to 18 seriousness levels. We have incorporated a formula. The red boxes under the 9+ column, those are anchors. Excuse me, not the 18. The 60 and the 120 are anchors based on a statutory maximum for class C and class B offenses. The red box on the left under the criminal history score 0, the 240, that's a mandatory minimum for murder 1, and that's the only offense under that seriousness level. So we use that as an anchor. We are incorporating straddle cells. So for example, criminal history score 3 with a seriousness level 3, that's 4 to 13, the presumptive range, and our guidelines are presumptive. That would be 4 to 13, or you see 5 to 17. Our hard line at between local and state was 12 months. Anything 12 months and less went to jail, 12 and a day or higher went to prison. So we're creating straddle cells. We're keeping that straddle cells and getting rid of that hard line. There's the hierarchy for the offense class, like I had mentioned, based on the statutory maximum, and we have elevated all serious violent offenses. Some of them were around like seriousness level 11 or 12, and those are all going to be 14 and above now. And again, this is just draft. This is preliminary. This is the recommended, the proposed grid. Next page, please. And so we gained a little color, like Pennsylvania, and we have zones, again, like Pennsylvania. Some of these will kind of apply to current sentencing alternatives, such as zone 3 is, we already have our drug offense sentencing alternative and our family offender sentencing alternative. The pink includes a new alternative called scissors, and that stands for Community Intermediate Sanction and Reintegrative Services, and that falls under the straddle cells. We have a current funding model for our juvenile court block grant, which has been successful. So the funding model will be based on that. That may not mean much to you, but just letting you know we have an existing funding model that we're using as a template for this. The details are still being worked out as to what that's going to look like, and that might be one of those items that either gets pushed to next year or may go to another task force or another work group, because we don't really have treatment providers on the criminal sentencing task force. And those would be important voices to have at the table when we talk about this. Next slide, please. For the criminal history scoring option, these are some of the multipliers that we have that we are looking at, and one of the recommendations is to get rid of all offense-specific multipliers. So, for example, burglary 1, if your current offense is burglary 1, any prior burgs count as 2 points. Any violent offense or serious violent offense, whether they're burglary or not, count as 2 points. So we're looking at getting rid of a lot of that and kind of getting back to a basic scoring. Next slide, please. And that general basic scoring rules would be adult offenses count as 1, juvenile violent count as 1, juvenile nonviolent as a half. We started talking about juvenile points, but there's currently a bill that's been coming up each year for about the last 2 or 3 years that's looking to eliminate all, and some of the members of the task force are supportive of that bill or behind that bill, so they couldn't agree to anything other than what that bill proposed. So we decided not to. There's no way we could get consensus on anything, so we moved on from that. So the criminal history scoring option would include a column, again like Pennsylvania, with the repeat violation. So we have a percentage, and what that would be is that 10% would be the maximum of add 10% of the maximum, how am I saying this, of the upper range, I'm getting confused. If the range is 10 to 20, you take 10% of that 20 and add it on and extend the upper range. If So it's 10% of the cell maximum or 1 month when you get down to the lower cells. This helps add transparency, we feel. It increases judicial discretion. It offers more individualized sanctions, and preliminary evidence seems to suggest racial disproportionality in the application of multipliers. So getting rid of those, we hope, will help address that issue. Next slide, please. So as far as aggravators go, again, we're adding a column for those, and that's a specific amount that, again, would be added to the maximum term of the presumptive range. So increasing the judicial discretion again. Potentially this is advisory, it's not a required. It's based on a single aggravating factor. So if there are multiple factors, that would, we expect, be a basis for sentencing above the advisory amount, making an aggravated sentence. Of course, that does, in Washington, that opens it up to appeal. Again, we feel this adds transparency, reduces disproportionate application of aggravated departures. There's aggravating factors found to be a source of disproportionality in sentence lengths. It's consistent with the concept of bounded discretion, so increased discretion, but yet it's still bounded. And we felt it's a middle ground or a more balanced approach to discretion. Next slide, please. And that is what our final grid, the final proposed grid, looks like at this point. Next slide, please. Some of the discussions that we still need to have is we're waiting for the results from the SAC on the analysis of the criminal history score. That should be coming any day now. Again, like I said, the details of the scissor sentencing alternative, I'm not sure what we're going to do with that. The washout periods, we haven't really discussed those. Mandatory consecutive sentencing, we're still talking about that. Persistent offenders. Retroactivity is a big conversation that we have not had yet. But I think we need to have something to say this is what would be retroactive. So we're waiting till we get to that point. As well as ongoing monitoring and research. The SGC just has me. So it would be really, really important to, once so many of these changes, whatever they end up being, are made, that there's ongoing monitoring happening. And that's what the SGC did originally back in the 80s and the 90s. And then the next slide is my contact information in case there's any other questions, but I am happy to answer any questions now. And I'm sorry if I rushed through that. It was a 30-minute presentation I was trying to bring down. So if you need me to dive deeper into anything, I'm happy to do that.
Yeah, that was great. I have a feeling that all of these conversations are just the tip of the iceberg, and we might have people back. Any questions from the commission? Commissioner Larkin.
Thank you for the presentation. It sounds like, you've been at this 2 years, 3 years. How much more time do you think it'll take to get to the end point?
Well, that's the thing. We have until June 30th, 2023, because this is directed by the legislature. They assigned our due date, and it's only because they extended it that we are still working on it. But the facilitators are pushing hard to get at least a grid proposal done by the end of this year. I think some of the legislators that are in the task force are considering moving on with a proposed grid regardless of where the task force ends up. So it's important for the task force to really come together and provide some feedback on that. So some of the other items will be discussed next year. There's also reinvigorated interest, I should say, more interest in reinvigorating the Sentencing Guidelines Commission. That this, so many of the tasks that the task force doesn't have time to do, or more detailed, is perfect for the Sentencing Guidelines Commission. So there's talk about adding a few more staff, particularly research staff, to help provide, because that's where we're missing sorely right now.
Any other questions? All right. Oh, wait,
Let me-
Commissioner
let me-
Middlebrook.
Oh,
Oh, and then Commissioner.
Thank you, Madam Chair. Carrie, I was curious on this column that's the add repeat violation. Is that basically if someone was on custody status and then commits another crime? Is that how that's being, is that, take that into account?
That's for a new conviction. So if they have a new conviction and they have the judge is taking into consideration their prior history. If they have a currently right now it's if they have a violent offense, a serious violent offense, or a repeat domestic violent offense, and there's a specific list of those. If they have one of those in their history, this column comes into play. If their current offense is a serious violent offense, but they don't have one in their history, this column does not come into play. Does that make sense?
Yes. Yes, thanks.
Commissioner Knudsen.
Well, that's what I was going to follow up on as well. I'm not sure it makes total sense to me. So how is that different from your the criminal history score? So you've got your prior offenses, your criminal history score, and then so a repeat offense is already considered in the criminal history score, correct?
It is currently, under the proposal, this column would take the place of the multipliers in the scoring rules.
So you count up, so essentially where you're sort of moving to is the criminal history is sort of counting the number of priors in some way, and then this column is looking at the quality of that, the types of offenses in that criminal history, and sort of modifying or aggravating the range if certain offenses are part of that criminal history.
Correct. So for violent, serious violent, or those specific domestic violence offenses, those had 2 or 3 points associated to them in the scoring rules. So now those offenses would only count as 1 point, but it was felt that if they had one of those in their history, that there should be a greater penalty, potentially a greater penalty. And what the 10% does is it expands the presumptive range. So it allows the judge to make that determination if this situation warrants a higher penalty or not. We also feel that it's transparent. In the scoring rules, those are hard and fast. There's really no way of getting around the extra 2 points because you had a serious violent offense in your history. It's also, the scoring is not very transparent. It happens in the background. We have scoring sheets that attorneys can use, but as far as the calculation of it, that's where it happens, is between the defense and the prosecution, and the general public and victims and families. They don't see how that scoring actually happens.
Any other questions? All right. Well, thank you again so much for coming. I just find it fascinating to see this sort of variation in, all the different ways that commissions construct their different guideline systems. We've definitely seen some, elements in your guidelines that we don't have, and in the Pennsylvania guidelines today that are just different from the way that we take things into consideration. So I really appreciate you taking the time to come here and show us some of those things, and also talk about the revision process that you're going through.
My pleasure. If there's any other questions or any other help, I'm happy to offer.
All right, thank you.
Thank you. Thanks.
Thank you. All right, folks. We have a new member today, and as our tradition is to do introductions, we have a new member. Now we're an hour into our meeting, so it's a little backwards from what we normally do. So I'd like to take a moment here to welcome Commissioner Ibrahim to the Sentencing Guidelines Commission. I'd love to have Commissioner Ibrahim come online and tell us a little bit about himself, and then if we could go around the commission and also just introduce ourselves to him and tell him a little bit about who we are, just sort of name what we represent, where we work, that kind of thing. Take it away, Commissioner Ibrahim.
My name is Mahmoud Ibrahim. I go by Mo as well. I have been a police officer for 5.5 years. I'm worked in 2 different departments now. I've seen the commission videos online, and I've reviewed some of the things, and I was interested in kind of being part of the commission, and I'm happy to be here. It's a lot of interesting things or conversations that you guys have, and for my last meetings, it's actually eye-opening as well. But that's who I am.
All right, welcome. I'm going to lead us in going around the room real quick so that you know who we all are. So I'm Kelly Mitchell. I'm the chair of the commission right now. In my day job, I'm the executive director of the Robina Institute of Criminal Law and Criminal Justice, and we do research on sentencing guidelines, probation, and parole. I'll pass it over to Commissioner Middlebrook.
Hi, welcome, Mo. I'm Catherine Middlebrook. I am the Chief Appellate Public Defender, so I'm the head of the Appellate Office of the Public Defender System, and I am the Public Defender Representative on the Commission.
Pass it down.
I'm Brooke Morath. I'm a public member on the Commission and victim representative. In my day job, I work in a neuroscience lab with Mayo Clinic.
Excellent.
I'm Michelle Larkin. I'm a judge on the Minnesota Court of Appeals. I'm the designated representative of the court by the Supreme Court Justice. Prior to serving on the Court of Appeals, I served on the District Court bench, and before that as a public defender in Hennepin County.
Let's go over to Commissioner Knudsen.
Good afternoon, Officer Ibrahim. I'm David Knudsen. I'm a district court judge in Dakota County in the 1st Judicial District. I've been on the bench for 18 years. And prior to that, practiced basically general practice of law for 18 years as well. And 12 of those years, I also served as a Minnesota State Senator.
Commissioner Moore.
Thank you, Madam Chair. Welcome to the Sentencing Guidelines Commission, Officer Ibrahim. It's great to have your voice a part of our organization and our commission. My name is Gordon Moore. I'm the Chief Justice's designate to the Sentencing Guidelines Commission. I'm an Associate Justice of the Court, have been for the last 2 years. Prior to that, I spent 25 years in way outstate Minnesota in Nobles County. I was a district court judge there for about 8.5 years. Before that, I was county attorney for 3 terms. I also served as a private lawyer, city attorney, and school board member. And I started my career at the Attorney General's office many years ago. But it's great to have your presence with us today.
Let's do some folks online. Commissioner Hansi.
Welcome. So my name is Tanya Hunsey. I am formerly incarcerated and also the Health Equity Director for a national nonprofit who aims to end incarceration and poverty for women and girls globally, and have worked on a lot of policy within Minnesota and a lot of other community work towards supporting people who have been incarcerated or justice involved.
Commissioner Ladd.
Thank you and welcome. I'm Kyra Ladd. I'm the Wadena County Attorney, which is located in the 7th Judicial District. I've been the Wadena County Attorney for 16.5 years. And I am the county attorney representative on the commission.
And Commissioner Estrada.
Welcome, Commissioner. My name is Valerie Estrada. I am the probation officer representative. During the day, I work for Hennepin County. I've been in Hennepin County DOCCR for approximately 17 years, most of that being adult and most recently moving to juvenile probation.
And back into the room, Commissioner Schnell, we're just doing introductions to our new member. If you can introduce yourself.
Thank you. Welcome. Paul Schnell. I currently serve as the Commissioner of Corrections for the state. Prior to that, I was law enforcement for about 30 years.
All right. So welcome again. You sort of hit us at a very interesting time. It seems like your very first meeting was our roundtable, which couldn't have been more interesting. And I hope that we have a long relationship with you on the commission. All right. I think that's everybody. Yeah, I think I actually succeeded in getting everybody, right? Right. Okay, let's move on. Let's move back to the agenda. So item number 6, budget change request. That's neat.
It is. Thank you, Madam Chair. So I kind of teed this up a little bit at our last meeting. This is more of a presentation, and based on our agenda change, we'll have kind of a final version of this to present to you next month. Based on your input today and also based on our conversations with our minute staff, who will help us identify exactly the cost of this. So I'm calling this sort of campaign, I'm styling it as Advancing Sentencing Policy and Data for Minnesota in fiscal years 2024, 2025, and beyond. And I'll unpack that a little bit in the slides to come. But first, I want to talk to you about your role with respect to the agency. So when I'm talking about the agency, I'm talking about the part of the Sentencing Guidelines Commission that spends money, basically the part of the commission that I'm in charge of supervising under your oversight. So what's your job with respect to the agency? Well, you have a general responsibility of an agency oversight body, and that part on the left is green because the state of Minnesota executive branch follows the federal government's green book. The GAO has a green book which talks about what good practices are with respect to running governmental organizations like this. And entities should have an oversight body, and that's what you are with respect to the Minnesota Sentencing Guidelines Commission agency. You oversee our operations, you provide constructive criticism to me if we're veering off course, and where appropriate, you make oversight decisions so that the agency achieves its objectives in alignment with the agency's integrity and ethical values. That's not to say that I involve you in all decisions, but I am accountable to you, and I should be reporting to you as far as what's going on in the agency. But there is a statutory specific responsibility, at least as I read our charter statute, with respect to personnel. And that is that the commission, and this is a quote from it, you may select and employ me, obviously I report directly to you, but also your duties include approving the hiring of any clerical help and other employees. So the commission shall approve the hiring of clerical help and other employees is how I read this. Now, I don't take that to mean, excuse me, that the commission is involved in every hiring and personnel decision that we make in the agency. But if that clause does mean anything, I think it at least means, and this is really how I interpret it, that you are responsible for guiding the personnel structure of the agency. So to the extent that some of these are talking about modifying that personnel structure, one of these involves hiring a new full-time permanent employee. I think it's important and appropriate and required that you do approve that. So on the subject of personnel, this is an overview of our agency staffing over the past 15 years. The blue line is the actual agency staffing at 2 points in time every year. So every year we pretty much publish two things. We publish a report to the legislature in January, and we publish the sentencing guidelines in August. So I took each one of those and counted how many staff members were listed on the cover page of those documents. And from 2007 to now, and it was at 9, and then it went down in 2010 to 6, and it's pretty much stayed at 6. There were some times where there were not 6 people, but those were really situational. It was due to attrition at the time. And in fact, since 2012, 4 of the 6 positions have remained stable. Like those are the same 4 people in those 4 positions, and they are at the same promotion level that they've been at for the last decade. And the only difference is me, and then the research analyst position has switched out a couple of times, but a lot of personnel stability for the last decade. The green line is maybe worthless, maybe not, but it's essentially taking the ratio of how many people we have per 10,000 cases that year. So it kind of shows you that the work is, the staff burden, staff has been doing more essentially. Well, 2020, the line goes up because there were fewer cases in 2020. But overall, we're kind of, you could say, doing more with less. And some of that has been, technology has helped us on that, but also there have been more requirements asked of us over time. So I don't think technology has really gotten us ahead. I do feel like we're getting behind in some things. And I think that was pretty evident when there was a hiring freeze in 2021, which is why that line dips down there. And we did really struggle just meeting our obligations with respect to you and with respect to the public in our data analysis and training and so forth. So now let's talk about money. This is our budget picture, and the pie chart on the left shows you that almost all of the expenses, 92% of our agency expenses are compensation. Compensation is salary and fringe. So not all of that money goes into the pockets of the employees, but it is, at least not directly. But those aren't really things that we have any control over. Those are pretty much governed by bargaining unit plans and how long people have been working for the state and so forth. The 8% is the operating expenses. That's rent, that's computers, stuff, the tools that we need to do our job. And that really is kind of a shrinking slice of the pie. We try to operate a very lean organization. And the chart on the right shows the actual historical spending per biennium. The state of Minnesota does biennial budgeting, so FY 2021 means it starts on July 1st of 20 and ends on, it starts on July 1st of 2019 and ends on June 30th of 2021. So it's a 2-year time period. So what we're talking about now is the biennial budget cycle for fiscal years 2024 and 2025. So keeping in mind, we're already in fiscal year 2023. Fiscal year 2024 will start on July 1st. Right now, there's $0 allocated for this agency starting on July 1st of 2024. That's the job of the next legislature to fund that. But this is the whole process leading up to that. So it really starts on October 17th. That's the day that the agency is required to submit change items to Minnesota Management and Budget, which is the bookkeeper for the executive branch. The next item, and so the whole context of this is, what are we going to present on October 17th to MMB? What are we going to ask for change items? Then November 8th is the election, which is important because this year the governor's office is on the ballot. So so the decisions that I'm talking about to the right of the election will be made by that governor-elect, whoever that is. And we don't know who that is at this point. And then in December, there's the budget forecast and the governor makes decisions, although I suspect if it's a governor-elect, that probably is pushed off to January. That budget forecast is pretty critical. It's not the final budget forecast on which legislative decisions are made, but it gives everybody an idea about how much money is going to be available. And to be clear, I'm anticipating this is going to be an unusual budget year in that I think there's going to be quite a bit of money available. The reason I think that is because there was quite a bit of money that was available for the supplemental budget that the legislature considered earlier this year. And the legislature, while it did spend some of that money, left most of the money on the table. So it is, it will be available, subject to, whatever changes there might be with respect to economic changes and anticipated tax revenue changes and that sort of thing. I'm anticipating that there will be quite a bit of money available, at least for one-time spending and that sort of thing. I don't really know that, but we'll find that out in December. And we don't have the luxury of waiting until December to make that. And I will say that, you may not all know this, but Kelly was my predecessor in this job. And she can attest to the fact that this is an unusual circumstance to have a situation where the state is, I anticipate, going to be flush with money. And this presents opportunities that are not always available. Sometimes at this point, we're pretty much thinking, what can we do to survive, essentially? But we're in a different situation here. And I'm not suggesting we should spend money because money is available. But if there are things that we want to do that we can't do because we don't have resources, now is the time to think about doing them because we do have resources, or at least that's what I'm anticipating. So then in January and February of 2023, it's January if it's an incumbent governor and February if it's a governor-elect or a new governor. The governor would propose the budget to the legislature, and then the legislature meets for session from January through May. And during that time, we hope they adopt an FY 24-25 state budget. If they don't adopt that budget by June 30th, then that's what triggers a government shutdown. And then July 1st is the beginning of FY 24 and the beginning of the new biennial. So that's the timeline for the biennial budget cycle. So as I told you at the last meeting, I've been doing this job for many biennial budget cycles. I think this is my 5th one, and this is the first time I'm really proposing change items. And these are the 4 change items that we're considering proposing. And the 4 items where I'd really value your feedback. The first is comprehensively reviewing the sentencing guidelines. The second is fully integrating with the court information system. The third is expanding analysis of sentencing related data. And the 4th is improving fiscal transparency and agency independence. So let's talk about the first one, comprehensively reviewing the sentencing guidelines. And this really was, well, from my perspective, triggered by conversation that we had at the NAS conference between me and the chair. But I think the impetus was the presentation at the NAS conference from Pennsylvania and Washington, which we heard from earlier this meeting. But if you just kind of take a step back and look at the Minnesota sentencing guidelines, they were the product of an intense but brief effort by the first Sentencing Guidelines Commission. So it was formed in mid-1978, and it had until January of 1980 so about 1.5 years to get a lot of work done, basically to build the nation's first sentencing guidelines from nothing. And it accomplished that. It published the sentencing guidelines in January of 1980, and those took effect in May of 1980. And they structure felony sentences statewide. They have been updated many times. They've been reviewed in part, but never comprehensively, as far as I'm aware. Another thing that I think is important to note is that when the guidelines were first promulgated, the commission was not directed, as it is now, to give primary consideration to public safety. That was something that was added to our charter statute in 1989, I believe. Now, what's significant about that is the basic structure of the guidelines hasn't changed, even though the commission's mandate to consider public safety at the forefront has changed. Also, what's interesting to me is that other sentencing guidelines from the 1980s have recently undergone comprehensive reviews. Pennsylvania guidelines established in 1982 and Washington guidelines established in 1984. This slide shows some questions the comprehensive review may answer. Now, to be clear, this is not a roadmap for how the comprehensive review would be conducted. And I don't intend to imply that all of these questions or any of these questions would be part of the comprehensive review. I'm just throwing them out as sort of some ideas of things the commission might want to consider in the comprehensive review. I don't view the timeline right now for the budget request as being one that allows us to map out how the comprehensive review would actually occur or what criteria would be used in what the comprehensive review would focus on. But here are some issues that are interesting to me anyway. Why are criminal history scores increasing? We've seen that in past presentations that, it's for some reason criminals seem to have longer and longer criminal history scores than they used to. Why are presumptive sentences increasing? How can we most efficiently use correctional resources? And that was a consideration that the commission was given in 1978, and it continues to have as a consideration. Do severity levels reflect culpability and harm accurately? So that's the vertical axis of the grid. Is that appropriate? How can the guidelines be simplified? And that was something that Commissioner Larkin mentioned in her letter to you yesterday and also in her remarks earlier. How can racial disparities be ameliorated? Is the role of criminal history in punishment balanced? We heard from Pennsylvania that their new proposal is going to limit the role that criminal history can play to not more than double the sentence. So for the same crime, two people will get sentences that are at least somewhat similar, regardless of their criminal history. Are the right tools available to address serious and violent crime? And that's something that certainly both Pennsylvania and Washington discussed, and something the commission addressed a few years ago when it created the severe violent offender modifier. What have other guideline states learned? Obviously, we've heard from a couple today, but we could certainly do a deeper dive. Why are departure rates so high for many offenses? Certainly, departure rates have climbed over time. And the core question, which is the only one I'm putting in bold because it's the one that the statute requires you to look at first. How can the guidelines maximize public safety? So again, this is not, the reason I put these in thought bubbles is because these are just some thoughts about how you might do it. This is not intended to be any kind of organization or structural roadmap for how the comprehensive review would occur. Don't know how that would go. But here's a concept of how it could be resourced. So because, and we looked at Pennsylvania, Pennsylvania's review has been going on, as I understood it, for a decade. So.
I don't want to do that.
Yeah, I don't want to do that either. But I mean, that's one approach. I mean, at a minimum, I'm pretty sure it's going to take at least 2 years. So I think we're safe, and that's how the legislature works in 2-year chunks, right? So I think we're safe in asking for 2-year funding. And by the way, I will just tell you, you'll have to take my word for it. We don't have the resources to do this in-house, right? We don't have free staff just sitting around with nothing to do to do this comprehensive review in any kind of meaningful way, or it would just take forever. So we're looking at research staff for one biennium with a possible extension into another biennium, or maybe it would be a different kind of, maybe it would be like, writing staff, somebody to to write up the guidelines. There's some different kind of expertise, but these would be temporary positions, and the goal would be to report to the legislature no later than January 15th, 2027. Well, where did I get that date from? Well, my thought is that since most commission members are appointed or designated by the executive, that would take care of the next governor's administration. So the Walls Commission or the Jensen Commission essentially could get the work done. I guess there are more than 2 candidates for governor, so I shouldn't have assumed it's going to be one of those 2. But whatever the next administration is, that commission could get the work done by January 15th of 2027, and it wouldn't have to spill over into another administration. So I did list some resources required. Now, I just want to say, it's my understanding of this is how it could look. Just because this is in the request doesn't mean this is how it would have to look. Basically, what we would get, my understanding of fiscal, how appropriations work is based on this, we would get this amount of money for the biennium. And then if we needed to change how we spent it in a different way, we wouldn't be committed to this particular, personnel set, but this is a reasonable way, I think, where we could spend the money. How did I come up with this? Well, I talked to Reese Hester, who is a professor who did work with the Pennsylvania Commission. So he's familiar with how they did their process. Basically, this is sort of what he thought it would cost. Now, Reese quoted me for his time, which was lower than this, but he did say he was a junior professor. And this isn't for Reese's time, right? This is for a professor. We don't know who it is yet. That'll be decided at a future time. So I think this is maybe for somebody who's a little more senior than Professor Hester. And then 2, so that would be a contracted professor. So if essentially the way he explained it to me is you could buy out a quarter of that professor's caseload, or class load. And then that's about how much that would cost. And then we would have 2 full-time research staff, temporary state employees. And to be clear, we might not use those employees on this project. We might use those employees to backfill the work that the commission normally does, and then have one of our experienced research analysts go over to the project. So it's not necessarily the case that these 2 people would be on that project. But that's about what that would cost. So that's it for the comprehensive review. I'm going to just continue on. I'm sure we're all going to have some questions and discussion about this, but I just want to get all 4 on the table. The other 3 will go more quickly. The second is to fully integrate with the court information system. This is the one I don't have a number for you. We're meeting with Minute tomorrow, but I will have a number for you next meeting. So we receive a monthly data dump from the Minnesota Court Information System, which is great. But that data dump doesn't pass any documents to the commission, and data changes are not updated. So it's not a live thing. It's the way I think of it is, I don't know how many of you have banking apps on your phone where you can just check and see what you're, I know when I buy something at Target and I can see the balance has gone down immediately. It's kind of cool. So you see real-time changes in your thing. What we get right now is like a bank statement in the mail, and we can see what happened in the last month, but it's not a real-time thing. It's not updated, and we can't interact with it, and we can't get documents from it. So it's more limited. So we do, it's kind of like the last generation of the way to do things. And this results in wasted time and potentially missed information. Full real-time MinSys integration. MinSys is the acronym for Minnesota Court Information System. Full real-time MinSys integration, including documents, not just data, would save time and improve accuracy, and it would enable better sentencing data analysis for the public and policymakers. And I was just talking with Judge Knudsen before the meeting about, sentencing departure reports and how maybe that whole process for receiving sentencing departure reports could be improved through MinSys integration. And it certainly would be improved just to be able to get those departure reports. That would be a prime example of documents that we can get automatically without having to go in and pull each one out. But perhaps it could assist the judges as well. These costs, unlike the last one, would be an ongoing. Some of these would be one-time costs in setting up the data structures that are required to make this happen. And some of them would be ongoing to keep it happening. But I will be able to report those. I expect to be able to report those costs to you in October. Number 3 would be strictly an ongoing cost. So that's, and by ongoing, I mean past the current biennium. So we currently collect more data than we have the capacity to analyze. An example of this is state of adjudication data. And I think this problem is only going to get worse. I view it as a problem. I mean, that there is information out there that might be able to benefit policymakers such as yourselves, such as the legislature, might be able to benefit, inform members of the public, which is part of our mission, but we aren't analyzing it because we don't have the capacity in terms of research staff to analyze it. And I think the problem's only going to get worse because there's only going to get better and better information out there. Like when we get the MSGC integration, we'll have access to plea bargaining data. Well, guess what? It says in our charter statute that we're supposed to be analyzing plea bargaining information. Do we analyze plea bargaining information? We do not. We don't have the capacity to do that. But maybe we could start growing that capacity if we had additional staff. The Department of Corrections is currently proposing public data, safety data infrastructure, which would be really cool. Would we be able to do anything with that? I don't know. I don't know how we would if we didn't have additional staff. So that's essentially what we're trying to do. And I don't want to come across as saying this is a guarantee that this is all we'll need for additional staff, but this would at least give us some free capacity to be able to do that. And it is our obligation to be the state's clearinghouse and information center for sentencing and related data. And we're not entirely fulfilling that obligation. And it could include more recidivism research, which I think goes back to the whole public safety thing. So what we're suggesting here is one permanent full-time research analyst supervisor senior. That's one position above what is our current highest research staff position. So that would be a supervisory position, which is not me. I mean, statutorily, I am called the research director. By tradition, it used to be there was a research director and an executive director, and those positions kind of merged. I'm not suggesting this is a research director, but it's at least somebody who knows research and is in a supervisory position, and I think can improve the research systems that we have. So these are, as I said, ongoing annual costs that are shown there. And again, that's not all salary, that's salary and fringe. And the fourth ask is improving fiscal transparency and agency independence. So although the law requires us to reimburse DOC for administrative services that DOC provides to us, right now we're freeloading. DOC gives us free accounting and human resource service. Instead of money, there's an unwritten interagency barter agreement where the commission provides prison population projection assistance to DOC. And my understanding is that used to be a bigger project for MSGC, but since DOC's, they've really developed some really cool technology to be able to forecast prison populations. So we still are involved in that process, but it has gone down quite a bit. So way back in 2002, the legislative auditor recommended documenting this arrangement, but it hasn't happened. And rather than document the arrangement, which may or may not be sound, I think a better practice both for fiscal transparency and agency independence would be to contract with the Department of Administration's Small Agency Resource Team, or SMART, for accounting and HR services. That's what they do. They specialize in meeting the accounting and HR needs of small agencies exactly like ours. And the annual cost for that would be $50,000 ongoing. And you know, that would sort of, I'm not saying there are any issues with independence that I feel like we're doing something differently because we're beholden to the Commission of Corrections, but I think it is better from a fiscal transparency point of view and an agency independence point of view to pay our way. And that's really what the law requires us to do. So through these one-time and ongoing expenditures, the legislature would update this is kind of my pitch at the end, right? They'd update the state's aging felony sentencing structure. By felony sentencing structure, I'm talking about the sentencing guidelines, ensuring that it is redesigned from the bottom up to promote public safety, which has never been done, or at least that wasn't the primary consideration back in 1978, 79. Broaden and deepen our data analysis, giving policymakers and the public better tools to make wise decisions in the area of crime and punishment, and improve the agency's fiscal transparency and independence. And the question I had was, does the commission endorse these change items? So let's discuss that question today, and I'll ask you for a decision next month. So subject to your questions, Madam Chair, that concludes this presentation.
All right, thank you. Do we have comments? Commissioner Moore?
Thank you, Madam Chair. Nate, would you be able to talk a little bit about the differences in staffing that your agencies had? Seems like a pretty dramatic reduction in staff from like 2007 to 2011, and that may have preceded you.
It certainly did. Yeah, I'm kind of, I mean, my era has kind of been pretty static, and I think Kelly, I think your era would have been pretty static. So I would probably get Ann on the line to answer that, unless you want to jump in on it.
Well, I mean, all I can say is I came in 2011, and the first thing I did was shut down the agency because that was the year of the statewide shutdown. So I think that we were in, it was really fun. I got to spend time with my kids in the backyard. But it was, the state was in a period before then of fiscal contraction, you know, really, and really budget crises. So I think that as people were leaving the commission or leaving the staff, we were not able to replace them. But one of the staff members who've been here the whole time could confirm that. We certainly couldn't ask for more staffing when I came in.
And is there anything you'd like to add?
Hello, everybody. This is Ann Wall. We used to have, we went up in staffing when we decided that we needed more help with training. We had a full-time trainer as part of the agency staff, and we just decided we couldn't afford that anymore, you know, as people got raises and as costs went up, other costs. And the agency kept moving around as costs changed. And for a while, we were stuck over in this warehouse down by the river. And that was, I guess, because that was where the rent was cheapest. And so we've had a lot of changes to accommodate budget restrictions because I guess nobody ever thought that we had the room to ask for increases during those lean years.
Other questions or comments, Commissioner Schnell?
I mean, I do think that, you know, I think that this is one of those situations and times perhaps where it would be wise for the commission to ask for what it needs, truly ask for what it needs. And you know, the legislature sometimes the blessing of a lot of money on the bottom line is it's actually harder to manage how you're going to disperse those dollars in some respects. But I think it would be wise. I was thinking about your presentation, Nate, and I certainly am 100% supportive. I think you know we need to make this kind of investment. I guess one of the questions I have, especially as I was listening to the enterprise approach that was talked about in Pennsylvania. And that adds a level of complexity to this. And yet I think we talk around those issues so often that I do think that we can't continue just to not look at that more and how it relates. I was just looking at the numbers rated, just the number of prison commits by virtue of probation violations. And while those numbers, were as high as, 250, 300 a month. Now they're down a little bit, but still it's significant that at any given time, 25 to 30% of the people that are in prison are in there because of either probation or release violations. And as a matter of policy, how do those things get factored and managed and some of those sorts of things. And so as we think about evidence-based practices, and we think about issues around resource development, and we think about the work that's being done right now to talk about, what should happen from a probation standpoint, and how do we adequately, resource probation across our state to make sure that it's not inequitable, and that the services that people need they can get, because the research tells us that's what's going to actually create more public safety. And so I think there, how do we connect the Guidelines Commission work with these other kinds of issues that certainly have to be the interests of the courts, that when you impose a sentence, I'm absolutely confident you want people to be better ideally when they come out of it. And so how do we make sure we connect these issues? And that's the one thing that I think, as an agency who certainly has a connection, and we look at some of these things, if there are ways that we could collaborate more, whatever that looks like, I just hope we don't limit ourselves at a time when public safety is a paramount concern, and we're all concerned about outcomes, and making sure that we're putting our resources to work in the best way possible for the good of our state makes a ton of sense. And the bottom line is that costs money to be able to answer these questions and establish policies that achieve those ends. So that would only be, my only suggestion is that we as a commission really think about the scope, and maybe it should be a bit broader.
Commissioner Larkin?
Has the legislature indicated to this group in any way in recent years that it wants a comprehensive review and rewrite of the guidelines? I assume if it had, you know.
Yeah.
So, I mean, it depends maybe on how you define legislature. I know I can't. Certainly not the legislature, right? Not in terms of a vote that was enacted.
Commissioner Larkin?
And if we were to do a comprehensive review, why do we need a professor involved?
That's really, well, you can answer it too, but that's really because some of the analytics that you need to really look at the effects of criminal history and severity levels are higher level statistics that we don't do as often here. So we need someone who's more versed in those analytics.
Practically speaking, it seems like the Robina Institute is always available to come in and tell us about statistics and trends and the science. Why do we need to pay for that?
You have to pay us too. But honestly, you'd have to pay the Robina Institute too if you.
No. But I mean, when Professor Frazee comes and gives presentations.
Oh, sure, but he's not taking a data set and doing analysis on it. So you need to pay for that type of analysis. That's time. It takes a lot of time to do that kind of analysis.
Oh, I absolutely agree. But I'm saying, do we need that to do the sort of comprehensive rewrite that you're proposing? I mean, that's the direction you're going.
Well, and I don't know that it's a comprehensive rewrite. I'm not assuming what the end product will be, but I mean, it's just at least a comprehensive review. I mean, maybe the comprehensive review will say this is perfect. This does exactly what it should do, and it doesn't need any changes. But yeah, it could result in a comprehensive rewrite. I mean, I would assume it should be as data driven as possible.
What would be an example of if we wanted a higher level of analysis to the data? On what point? What would it tell us?
So I can tell you one example of research. Actually, Robina did present this to, I think we presented this to the commission. I know we presented it in the conference. One of our staff did this, and then the professor working for Pennsylvania did this. Looked at the criminal history score. Looked at people within each criminal history score, what their recidivism rates were within each criminal history score, and were the criminal history scores like at really differentiating well between recidivists. And for Pennsylvania, they found that sort of in the middle there, it was very mushy. You were really not getting a lot of bang for your buck to have as many criminal history scores as they did. And I think that's one of the reasons why they've decreased the total number across, because they were really not differentiating between recidivists and punishing recidivists differently. People in the middle were just as likely, were sort of recidivating at the same rate, regardless of the criminal history score. I can't remember if we had results like that for Minnesota or not, or if we even ever presented that to this commission. Do you remember if we did that?
Well, the Laskarensky research.
Yeah, that's what I'm talking about.
Yeah, that talked about how each time you went one cell to the right, how that affected the predictive value of the criminal history score for recidivism. Yeah, it wasn't.
I don't think there was a big difference in Minnesota if we presented that, but for Pennsylvania, it was sort of eye-opening for them, because they were really amping up punishment in the middle there when there was a range of people who were just as likely to recidivate and no more likely to recidivate than people with lower criminal history scores. So that made them rethink, like, do we want to keep pushing people that far, or could we get the same impact, lower prison populations with a different setup there? But that doesn't mean, like I said, that's just one thing that they looked at. They looked at a lot of different things. They also looked at offense severities and that sort of thing. Were you going to say something?
I was just going to ask, I think another thing we talked about in that July meeting was certainly looking at some of this racial disparity stuff.
Right.
From a standpoint of the racial disparities as it relates to our sentencing policies. And the extent, as Pennsylvania did, what in the policies actually exacerbate or further to the disparities. And I think we have a fundamental core responsibility to make sure that we're looking at that. And I just, because we're trying to do some of that even in the DOC, and it's super complicated.
Yeah, I'll just comment that for me, the reason that the comprehensive review is attractive is because the roundtable combined with NASC is really what did it for me. Is, I'm listening to folks at the roundtable, and I'm hearing like almost what could be considered competing interests, right? We have concerns about severe or repeat violent offending on one end, and do the guidelines do enough with that group? And then we also have concerns about, addiction, people who are committing crimes because of addiction. And then we also have concerns about racial disparity. And it just struck me that it's hard to tackle all of those issues at once, and that one policy change can sort of pull the threads out in ways that you don't intend it to. And so for me, it was like, how can we look at this a little bit more comprehensively so that we can address all of those issues, that we can meet the concerns of people who are concerned that, we have the right sentences in place for severe violent offenders, and that we can meet the concerns, make sure that we have the right responses for people who are driven by addiction, so that we can look at racial disparities and figure out how our policies whether our policies are exacerbating that. That would take some statistical analysis to ferret that out, and make, sort of a comprehensive, approach it in a more comprehensive pattern. Then I go to NASC and I'm like looking at these like additional columns that they're adding, going, gosh, we never talked about that as a solution. for custody status, maybe that's the way that we need to deal with it. But I'd be afraid to do that without knowing all the other potential impacts. So that's for me where it sort of hit the road, and I thought, well, maybe, feels like this would be a good time to maybe embark on a review, and one of the best times we would have for actually asking for funding to do it and potentially receiving that funding.
Madam Chair, Judge Larkin, I'll tell you, one of my big concerns is this. It's really, I don't know if it's one issue or multiple issues, but it's that chart that I showed you before where the presumptive sentence line is climbing up, and like are criminals really getting worse? Like why would the presumptive sentence line be climbing up? And then you look at the actual imprisonment rate, the sentences, and that's not really going up that much. So what's happening is not only is the presumptive sentence climbing up, and we know that the criminal history score is climbing up. Like, is that a data issue? Is that something about criminal history? Like, I don't know what's going on there, and it's very concerning to me. And also the fact that there's a gap that's growing there between those two lines. So in other words, the departure rate is climbing up. And I think there's a point at which the guidelines are going to break. If the departure rate keeps climbing up, that's at least my personal concern is at what departure rate do the guidelines just become unsustainable, where if the exception is more common than the rule, what's the point of the rule? And I'm concerned because that gap is growing, and it's growing larger, and it's not growing because the imprisonment rate is growing that much. It's growing because the presumptive imprisonment rate is growing, and I don't get it. I don't know why that presumptive imprisonment rate is growing, but I'd sure like to know. I think it's an important research question that will be pretty detailed. We'll have to figure out, what's the difference between a typical defendant in 2022 versus a typical defendant in, 1995, and why is is that really a different person with a different history, or are we just measuring history differently? What's happening? I don't know.
I'll get to you in just one sec. Commissioner Estrada has had her hand up for a while too. Commissioner Estrada.
Thank you, Madam Chair. I'll be brief. I just want to say I would support this proposal for the budget. I mean, even outside of the comprehensive review, Nate, you presented on this in the June meeting with the 3 other factors that you have listed here, and there's a clear need, but there's a need for increase in budget and staffing to be able to be more efficient and grab data that we as a commission have asked for several times, I think, and there's been a lack of resources for it. So I would support an increase in the budget and this proposal. In regards to the comprehensive review, I think we tend to be reactive a lot. I think this is an opportunity to be proactive. I think about, how many times has the legislature asked us to do a comprehensive review of just a section of the guidelines? Why wouldn't we do it for the full guidelines? I think that this is, again, an opportunity to be proactive in this. I also think that we have an obligation to continuously look at the guidelines and if they're working and if there needs to be adjustments, whether it's simplifying it or doing some of the things that have already been mentioned in this meeting. So I would support that as well.
Thanks, Commissioner Larkin.
Nate, can you dumb it down for me when you say the presumptive prison sentence is going up? Do you mean the number of people who qualify for a presumptive prison sentence is going up?
Right. Yes, the guidelines are calling for a higher percentage of felony defendants to go to prison now than they ever have. And I think that's true. I mean, it's pretty much a straight line up. So if it's not, maybe not this year, but within the last few years, it's higher than it's ever been. And yet the actual imprisonment is not growing at that great of a line. So the delta there, the difference between those two is getting bigger.
So could a person look at that and think, and again, not trying to argue, just trying to understand it.
Yes.
If we haven't increased boxes, and yet people are qualifying for presumptive prison, and they're not being sent. Does the prison look at that and say, well, that means those people are committing more offenses and their criminal history score is increasing, therefore they're qualifying for presumptive prison sentences, but we're doing departures, so they're not going to prison?
That is a hypothesis, yes.
What's the other hypothesis?
That there's something different about how we measure criminal history, or there's something different about data collection. I mean, yeah, there's at least three hypotheses jump to mind. One is criminals are just badder than they were before. You know, they're just worse. Two is we're just better at collecting data than we used to be. So criminal history would get lost in the cracks, and you know, the paper would get lost and people wouldn't know where it was. But now we're really good at it, and we have an electronic worksheet system, and we're able to collect that. And the third is that there have been policy changes, like making misdemeanors into felonies, that have increased the criminal history. And maybe it's a combination of the three. I don't know. But I'm just saying it's the fact that what I'm calling the delta, you know, that difference is growing, and that creates tension with a structured felony sentencing scheme.
We need to know beyond that why can't we just say, okay, this is a problem, we need to look at this and figure out how to reduce the delta?
Yeah, I mean, but we do. That's exactly what we need to do. But I'm saying I think that's a very complicated question, and it's not a question we have the resources to answer right now. And I think it's an important question. It's one of many important questions.
I have one other question, and it's escaped.
All right, Commissioner Moore.
Madam Chair, I'm in support of this conceptually. Obviously, there's detail that will have to be discussed, but I think there's a lot here that would be beneficial for us. I'm really intrigued with what Pennsylvania and Washington are doing on the probation violation. You know, Pennsylvania has the resentencing guidelines. Given what Commissioner Schell's talked about, the number of people being admitted to prison on probation violations, that's obviously an important issue. Then Washington, you noted the column that's being proposed to be added for repeat violation. I mean, the recidivism issue, repeat offenders obviously are a source of significant concern to the public and need to be for us as well. And it is hard to look at one of these issues in isolation. I appreciate what Nate's saying, is that I think if you single things out, you can gather data about what effects does that have on another portion of the guidelines. I guess from a standpoint of process, though, Washington was actually asked to look at a revision of the guidelines because of their issues that came up. That hopefully we won't go there. Was Pennsylvania, was it a self-initiated process with Pennsylvania where they approached the Pennsylvania General Assembly and asked for that?
I think that was self-initiated. I don't think they were given other responsibilities along the way that sort of prompted their wanting to do this review, but I think that it was self-initiated for them.
Madam Chair?
Yeah.
I mean, the Vice Chair alluded to this briefly, and I probably should have mentioned it. I mean, there's a standing order for the commission to meet for the purpose of modifying and improving the guidelines. So it's not like there's no authority to do this. It's just a deeper dive than you typically do in your monthly meeting.
Commissioner Larkin?
My concern is, so Pennsylvania is at this 7 years, 10 years. Washington is nowhere, well, it doesn't sound like they're close to the finish line. You know, we've got an agenda for today and we're almost at the end of the meeting and we've only covered one item. I mean, I just don't see realistically how you go to the legislature and say, we want to do this and we'll get it done in 1-2 years tops. I think that's completely unrealistic.
Well, my target is 4 years. Well, 3.5, I guess.
I think 3.5 is unrealistic. I mean, we've been doing criminal history point for 2 years, and we're not getting to that item today to resolve that. I think we need to be pragmatic in terms of what this group can take on. And although issues have been identified that could be addressed. And, I'm intrigued by this because what the judges are telling me is we want it simplified. But I look at what Pennsylvania did, and it's like, it seems to me they made it 10 times more complicated. They didn't simplify it. So I don't want to go in that direction. And it seems that we could ask practitioners and judges, what would simplify this process, and get some input and look at those things. But the notion that we're going to just do a comprehensive review, and I mean, that sounds great, but I think we have to be realistic about how productive it will be and whether in the end it's just going to end up without any real change. And in the meantime, we're just, could we just instead address particular issues that need to be addressed?
Well, my response to that would be no, we can't, because we don't have the staff to do it. Like, we literally don't. There's so many questions I've wanted them to give us data on, and they can't. Like, they don't have the capacity. So to really address things, we need to ask for the additional staff to work on these issues. And, we had, like, if we move forward, we're sort of in this place where we have to put a budget request forward, like now. So we're guessing as to what we would need, right? So we'd have to put the budget request forward, but then we would have some time, because we wouldn't get any money till July if we get it. So we'd have some time to figure out how we're going to go about this, right? And to work on it. I talked to you a little bit offline, and I said, I'm actually working with the New Mexico Sentencing Commission right now, and they did a survey of practitioners to find out what the issues were. And that was really illuminating, and it focused their work. And that's what they're doing right now, is they're focusing in on those things. So that was a good process to sort of identify where are the major issues that we need to work on. And I think we could do something like that, and we could spend a couple meetings sort of hashing out, like, what's the best approach for Minnesota. So nobody's saying that this is a preset thing that has, a playbook already written for it. Like, we get to write the playbook to figure out how we do it, but we don't have capacity to do anything right now. And I think it's time that we did. I think it's time that we actually took a better look at these issues. I'm tired of wondering what should be on the severe violent offender list, because I don't know how it was created. Instead, like, let's talk about what is that list, and what is it doing for our guidelines, and what, what's the rubric for how things should be on that. So, these are all the issues I think we could take up. I think you might have had your hand up.
I did. Thank you, Madam Chair. I would agree with what many people have said here about and support this request. On the comprehensive review aside, the other parts that we need the funding, the commission, they need the funding for the additional staff person. There's no question about that. And I think that we've discussed that before, and I fully support that. On the comprehensive review, I guess what I'm looking at is the same thing, is we need additional staffing to be able to help us focus in and do a review to start with. We got to start someplace. These guidelines were, created in 1980. That's a long time ago. And most of what came out of there was based on the parole system and what the parole board was doing. So they are pretty dated. Obviously, there's been amendments over the years, but it just seems like they're kind of piecemeal, and a bigger, broader review. The chair brought up the severe violent offender. There's some really good ideas from these other states that maybe would work better and take care of some of the other concerns that we have. And most important, try to simplify them for the practitioners. So I think that the time is now to try to request this money and see if we can get it to do that, along with the other needs that the commission needs.
Commissioner Schnell.
I would just quickly, because I hear Judge Larkin's concerns, and I don't disagree that it's a big lift. And yet one of the things that I was intrigued by Pennsylvania, well, process is messy, right? But I do think that, you know, the way they engaged, just this cross-section stakeholders early on to help do some of that stuff, you know, and I think if we could develop kind of a tight kind of timeline of you know, let a group of people do some of that stuff and come back to us, I think there could be really meaningful, thoughtful ways for us to kind of get at some of this and really expand kind of perhaps some understanding and get the perspectives of others as we do this. So, I mean, that would be the hope, and I think it might help guide our process, and potentially by doing that, we end up with a better product, one, two, more understanding. So, you know, I think there are ways to get at that.
Commissioner Knudsen.
So I'm wondering, in your thank you note to our two presenters today, if you could say, could you provide us some additional information about your process? So one thing I would ask is, what additional staff resources did you hire, plan for, or utilize in this analysis? So this is their chance to help us as we helped them back in the early 80s. So
Right.
they look to us, and now we're looking to them. So what can we glean in the next month before we make our decision? What can we glean from Pennsylvania and Washington? Specifically, what staff resources were required to do this? How would you allocate or request staff any differently, knowing how long your processes have taken? So what really was the charge then, or the role of this, of the analyst, the data analyst? What did you ask them to do? What kind of analysis on their guidelines was done? And then find out, again, what did this cost? But I also think, because the way that budget is presented, there's the line item as to the description. And I'd like we bantered around a bunch of issues that, oh, we need more analysis on this aspect. We need to look at racial disparities. We need to look at recidivism rates and criminal history score analysis. What impacts can we take a look at? What studies do we want to perform that we know right now? And Madam Chair, you mentioned a couple issues. I'm a little leery about the one we led off with because that's a very simple solution. There's a problem with the judges just simply not following the guidelines as to why there's a higher rate of departures. And that's certainly something we need to look at and figure out, well, maybe we've got those misranked, or the numbers aren't correct, but it's, so I don't want to highlight that necessarily, but all of those issues can be kind of corralled as the reason that we need to do this, plus just simply the passage of 42 years. And is it serving the public safety function? And I know we have a list from different stakeholders that, boy, the sentences are too light on these kinds of crimes, or felon in possession. They don't go soon enough. There's different issues like that we can say this is kind of part of the analysis. We'll look at this. So, and then if we could put together, just rough it out and maybe ask Pennsylvania and Washington, what were the timelines? What were the time frames? So there, we've got the bar chart from starting today. Okay, we started with this aspect of developing, and then we went to the public hearings, and then we did the report back, and then we did and then we do this. Kind of just a very rough out kind of time frame is it. We're going to have all that in our budget document in order to, because that's what's going to everybody. And so it really has to be there now. A little more fleshed out.
Madam Chair,
Yeah.
I guess I was assuming that that was going to take months to flesh out the process, to figure out what's the most efficient way to do this. Like, that's kind of, my thought was that's spring of 2023, that the commission discusses that process. I'd be amazed if we could come to an agreement on that.
I think we could do a high level one though, 'cause we
High-level
could do
We gotta
like
do it.
planning, analysis, hearings and input, that sort of thing. We can come up with a high level one.
And all of this is subject, as we were talking about the use of the fungibility of the resource that we might get additional money for is in the assignment of that person. But, all of this can be adjusted according to how they allocate the funds.
Yep.
Yeah.
And it's bound to be, but I think we've got to have a better framework, and this is the first time we've talked about it. If we can get some more information from Washington, Pennsylvania, we can try to, and then just come up with some of these things and get it on paper as to how we're presenting this request, these requests. And I think that would be helpful for the discussion for next time.
Can do that. All right. Probably enough discussion on that. We have 9 minutes. We could probably get through at least one substantive issue today. Thank you for the discussion on that. Let's move down to sex trafficking.
All right. So if I had one substantive issue I'd like to get through, it's this slide, because what you need to know is the timeline, okay? And the timeline applies both to sex trafficking and to the custody status amendments. So we got the mandate for the sex trafficking review on the left there. I think you've all seen that, and then that was expanded to include prostitution. There's no timeline required in the statute, but I think we've all kind of thought it'd be nice to get this done and take effect August 1st of 2023. So that's kind of the next time the guidelines will be published. In order for that to happen, this applies to all the changes. Here's the timeline. It would have to be discussed at the next meeting. That's according to the commission's first reading rule, which Judge Larkin put in her memo. It has to be discussed by the commission. A proposal to change the sentencing guidelines would have to be discussed at the next meeting. That's waivable by a 2/3 vote, but that's what the rule says. And then at the November 3rd meeting, it would have to be preliminarily adopted by the commission and forwarded to a public hearing. It would then have that public hearing on December 15th, and then it would have to be adopted at the January 12th meeting. It would then be reported to the legislature on January 15th. That is the timeline. So we don't have much time. Moving on to these materials, I'll just tell you what they are. I guess you'll have to read them yourselves, but it's, so the materials are, you have the estimated impact of the different sex trafficking and prostitution review options. So here, and then the sample draft language of the selected options. Now, there haven't been any proposals for any of these that have come to me yet. So I was just doing like the medium staff proposal for all this. Doesn't mean you have to do it. There's no action required in any of this. You can just say we did the comprehensive review and we think the status quo is just perfect, and explain why, and we're done. So it's no requirement to actually make any changes. But if there are changes that are going to be made, I just picked the staff recommendations. With the prostitution review, I did do an amendment based on the testimony we heard from the advocates, where they didn't like the idea of having a differential based on whether or not the child whether there was an actual child involved or a sting. So we've written that up 2 different ways, and you can review that. We've got sample language in there for that. And then with the custody status amendments, the only option that I've heard is Judge Larkin's proposal to just what I'm calling codify Bogdanovich, which is basically to eliminate the half custody status point, which the commission just created in 2019, to just say, instead of making that instead of dropping it down to half, essentially that would just drop it down to 0. So in any case where somebody earned a half custody status point, they would no longer earn custody status. There would be no computation of custody status in their criminal history, which, just to be clear, doesn't mean that wouldn't count in their criminal history. The offense itself, assuming it hadn't decayed, would still count in criminal history under the other criminal history score rules. It just wouldn't count under the custody status rule. And that would apply to lower level felonies and to misdemeanors and gross misdemeanors. And that's articulated in the sample draft language as well. Are there other options? So that Madam Chair, I'm just going to say I went all the way down to 8B, if that's okay with you in the interest of time. I'd be very interested to hear if the commission has other options other than the Bogdanovich codification or the status quo. So those are the two options that are on the table, as far as I know.
Okay, so if we look at aggravated sex trafficking, the sort of option that you put on the table as a baseline recommendation is to change that from a modifier to ranking aggravated as a higher level on the grid.
Right. And if I could, Madam Chair, there are two options. There's the yellow highlighting and the blue highlighting. The yellow highlighting is the Central Minnesota Human Task Force. I'm sorry, the yellow highlighting is the staff recommendation to make a difference depending on whether it's first degree or second degree sex trafficking that's aggravated. The Central Minnesota Human Task Force, which is the blue highlighting, says just rank them all at severity level A, because the legislature's created this big statutory maximum for all of them. So don't make a distinction depending on whether the person being trafficked is a child or not. And I think, I guess the staff recommendation does keep that distinction in there. The current guidelines keep that distinction. And anyway, I'll shut up.
So I guess if we look at the sex trafficking and prostitution review, do any of the proposals that the staff has put in front of us jump out as something that we want to talk about next time? Do you want them all to be brought back? Commissioner Larkin?
Can we at least put them on the screen so we can see what you're describing?
Sure. So
I don't think oh, there it is.
yeah, I'm not sure what to show you because this kind of gets into the weeds, but this is the 7C1 document that deals with sex trafficking. And essentially it's deleting this modifier. So 2G9 is gone, and that's the 48-month modifier right now.
Okay.
So it increases second degree by 48 months and increases first degree by 48 months. So the status quo right now is graded depending on whether the victim was a child or not. Basically the change here is, this is the ranking section. So now I'm on page 5 of that document. Aggravated sex trafficking first degree, under the yellow proposal, the staff proposal, that'd be severity level A, and then aggravated sex trafficking second degree would be severity level B. Both are presumptive commits at any criminal history score. It's just whether it's 144 months or 90 months for criminal history score 0. The blue option instead would rank just aggravated sex trafficking all the same. It wouldn't make a distinction between first and second degree as the guidelines now do, because the statute doesn't make that distinction. It doesn't have a different maximum penalty for second or first degree aggravated sex trafficking. So that's the Central Minnesota Human Task Force suggestion, is to rank it at severity level A, regardless of whether it's a child or not.
And if I'm recalling correctly, there was not a huge impact. Of course, the impact would be bigger for the blue option than the yellow option, but I think it wasn't very big either way.
Yeah, so.
Oh, okay.
That's the.
Okay, so if it's A and B, if it's A and B, the impact would be an increase of 5 prison beds. If we put them both up to A, it's 11. So it's fairly similar to how sentences are working out now.
Yeah, it definitely is an increase.
Yeah.
But there aren't that many of these cases, thankfully, so it's not that huge.
So for this one, would the commission want to bring both proposals back next month? Or are we leaning in a direction that we want to look at more, or none of this?
I hate to say this, but I have no idea what I'm looking at, and I know you put time and work into this, and I know we've had the presentations along the way. But the problem is we have the presentations, and then we talk about other things, and then we get to this point, and now it's 5 minutes before the end of the hearing, and what do you want to do? I'm in no position to make a decision on any of this.
Well, there's
today.
no decision.
Okay.
It's a discussion item today.
I guess
So-
I'm in no position to have an opinion for discussion, except to say, don't feel like I'm well enough prepared, and perhaps that's on me, but it's sort of like you prepare for what's going to take up our time. And now we're back to this, so it's like, if this is what we need to decide next time, let's commit to that and let's set the time aside to do it.
Okay. I'm not gonna throw stones. We have been talking about this all year. It's time to decide. We are deciding this next time. So everyone's on notice. We gotta read the materials and we're deciding it next time.
Bring it all back, yeah.
I'm sorry, Commissioner Chair.
I think we should
Madam
bring it all
Chair?
back.
Yes. Yes, Commissioner Ibrahim.
Can this be emailed to us so we can review it?
Yeah, you should have received it a week ago. We always send the materials out a week ahead. So we will have the staff just verify that you received it, and if not, then they'll work on making sure that you have all this.
Madam Chair,
I also did not receive it, so there's a couple of things in today's agenda that I tried to pulling from the website, because I did not receive these documents either.
I was going to raise the same point. For the most part, we've always received the materials as attachments, and all of the exhibits in the agenda have always been attachments. And for some reason, I agree, I didn't get I got some attachments in some emails, and then was referred to the online agenda to go in and find those exhibits for those agenda items or something.
Yeah, Madam Chair, there was some, I don't know if things were getting caught in somebody's spam folder, but some people were getting them, some people weren't. I know the judicial branch didn't get them, and possibly some others. So I suspect there was an attachment. I don't know which attachment was at fault, but there was an attachment that was getting caught in a filter of some sort. So that doesn't normally happen. It could have been, yeah, I don't know if it was sex trafficking. Well, you're in trouble if you can't send bad stuff.
That'd be awful. Okay, all right, so we have this, what the staff did is they took sort of the what their original documentation that they gave us, they had given us recommendations. And so they, because no one on the commission had strong feelings, they just ran the impact so that we could get a sense of what would that do. And I will give you, like, spoiler alert, none of it impacts prison populations hardly at all. So it's all very minimal impacts. If we were to move child pornography over to the sex grid, if we were to look at aggravated sex trafficking a little bit differently. So I think it's actually worth consideration by the commission to look at these proposals and decide if we want to do these things. So why don't let's bring it all back next meeting. Hopefully it will make it through all the spam filters, and then we would have to vote next time. We'd have to narrow it down, or we'd have to review it next time. We don't have to vote next time. We have to discuss it next time in order to meet our timeline. So, yeah. let's do that. Commissioner Larkin?
And I think one of the documents that have been provided in past or presentations, which was very helpful, was, okay, if you do these things, well, this could actually reduce sentences, which is counterintuitive. This would give a broader sentencing range. Could you provide that? Could you send that out to us today or tomorrow, while it's fresh in our minds, so we can just look at that document and focus on this issue as opposed to it being 8 to 10 things on an agenda? So that would be very helpful to me. And I know you've provided it, and I take responsibility for not being 100% fully up to steam, but we're doing a lot of things, meeting to meeting, and that's just not on my horizon for today.
Yeah, and I can do that. I will, I think the critical thing though is if you have something new,
Yeah.
I really need to know that.
Right.
So we can write that up or analyze that. So if there's something that you haven't heard that you'd like to hear, please let us know.
Yeah.
Because I think there was one option where you would rank it differently. I don't know. I just, if you could resend just that.
Yeah.
Because I too did not get the documents. Well, I guess we
Right,
established that.
Yeah, I wish I knew what was getting hung up, but I guess we'll find out. I'll ask you to reply when I send that out. But yeah, I will send out, and I guess the documents we've already done essentially will be the base materials for the next meeting.
Yep. That sounds good. Commissioner Knudsen?
So could we just get that whole package resent to us? And from the prior meetings as well on this particular issue. So rather than going back and trying to find which materials, which, 4A exhibit from 2 months ago applied to this sex offender or the sex trafficking issue. And if we could get all of that, within the next week or something, then everyone would have all of the materials in one email and be able to review what those proposals are. I think that'd be very helpful.
Yeah, and then as Nate said, so then your homework for the next week, because they would need some time. So your homework for the next week would be to take a look at that. And if there's something that you want them to write up language for and do an impact estimate for, then they need to know that, within a week or so that they have enough time to do it. He's looking at me like, yeah, no, that's not enough time.
No, what I'm actually thinking is, I will get this out to you tomorrow. If you don't get an email from me tomorrow, please let me know. I'll get it out by 3:30. So if you don't get an email from me by 3:30, please let me know, because it's something I hung up again.
Yep. And then on, since we need to wrap up, on the custody status issue, which was the last item on the agenda, the one proposal that staff wrote up language for and an impact for was your proposal, Judge Larkin. So that one is there. And there again, if somebody has another idea that they want written up and an impact estimated on, then the staff would need to know that fairly soon.
And actually, that had the largest impact, the codifying Bogdanovich, which I was kind of surprised about, because I assumed that, so why would there be an impact in just codifying the status quo? The reason there's an impact in codifying the status quo is because what's not necessarily the status quo is the effect of that half custody status point on somebody with a criminal history score that's 7 or more. Right now, there's a 3-month bump for somebody with a criminal history score that's 7 or more. And I didn't assume, although you could read Bogdanovich as saying we're getting rid of that too, I didn't assume that was necessarily the case, because, I don't think we have time. So what we assumed was that would be a change, getting rid of the 3-month bump for people who astonishingly have a criminal history score of 7, and yet they only have a half a custody status point, which I would have thought they would have had a full custody status point at that point. But there was an impact of negative 20 beds, and that's shown here. And this is the demographic impact on table 1 of document 8A1. It shows those 20 beds going down, and it shows the breakdown of demographically of who the occupants of those 20 beds are.
All right. Anything else? Do you have anything else? cover today?
Oh, I'm sorry, no.
No?
I didn't know you were talking to me.
Okay, all right, then we are, I will adjourn the meeting and we will see you, oh, wait, Commissioner Middlebrook, did you have something? Sorry.
Yeah, Madam Chair, I just want to clarify on the upcoming meetings. It's listed as October 16th, and that shouldn't be there on the agenda.
Oh, we do have to have public comments, Madam Chair.
Oh, I'm sorry, yeah, public comment.
The October 16th, that's a typo.
Okay, so it's
October
October
6th?
October 16th. Yeah, it's October 6th.
That's a Thursday.
Is the next meeting.
I have it on my calendar, yeah.
So it's 4 weeks from today.
Okay, I'm sorry, we have to move to public comment.
We're not meeting on Sunday.
That's what I thought, that's so good.
Thank you. All right, so at this point, I'm going to ask any attendees who are members of the public to raise your hand on WebEx. So there should be a raise your hand feature. If you can access that, please raise your hand. There's one call-in user who would not be able to raise his or her hand, and that person's phone starts 218 area code, and the next digit is 9. I'm going to unmute that person now. All right, you're unmuted. Would you like to make a comment? Apparently not. I'm going to mute that person. All right, and I don't see any hands raised, Madam Chair, so I think that concludes the public comment portion. There are some written comments attached to your materials.
All right, great. All right, then that concludes our business for today. We are adjourned. We'll see you all in October.
Yes.